more perspective on this, we're going to bring in Professor Louis Langham, who's with WMU's Cooley Law School. Thanks for being with us today, Lou. We appreciate it.
Sure.
So let's talk about this decision now, right? We have second-degree murder charge, one of them, for this April 4th incident. The prosecutor explained just a little bit why he didn't bring a manslaughter or a first-degree murder charge. And just help us break that down a little bit, this decision to go with second-degree charges, as we understand this wasn't necessarily premeditated.
That's correct. Well, the premeditation would have come in only if it had been charged as first-degree murder. So that's out of the picture. There was no planning on the part of the police officer, Christopher Scher. So now we're in the second-degree murder, which is what he was actually charged with. And when the prosecutor first mentioned that, I was thinking, okay, I didn't expect that totally. I was thinking more along the manslaughter. He charged him with second-degree murder, which is basically that he caused the death of Patrick Lyoya, and he intended to kill him or intended to cause great bodily harm. But then when he added in that a lesser included offense of manslaughter, which would take it down to a maximum of 15-year penalty, then I started thinking, okay, I understand what the prosecutor did and why he did it.
Certainly. You know, the other thing the prosecutor mentioned was, as he was laying out kind of the criteria for making this second-degree murder charge decision, is that it wasn't justified by use of force. And that really was the crux of this entire investigation, finding out whether that struggle, whether that fight over the taser would be enough to justify this act. He, of course, said that it was not, it will not. Is that still a defense that Officer Scher can use now going into this criminal trial, that he was simply trying to defend himself? Or is that just not going to work now that this announcement has been made?
Okay, well, Officer Scher will still have a defense. There was a struggle over the taser where Patrick Lyoya was attempting to disarm the police officer, and the police officer may argue, or his attorneys may argue on his behalf that, hey, I thought he was going to actually, if he had dry stunned me with the taser, he took one weapon from me, maybe he was going to take the other and kill me with it, and therefore it was justified in what it is I did. The only other argument that he could possibly have was that the gun accidentally discharged by him pulling the trigger, but he didn't intend to pull the trigger at the time. So I think that the prosecutor will have it's not an easy case to try, especially as it relates to the second degree murder part of it. That's why the lesser included offense of manslaughter, when you're looking at heat of passion type situations there. So I think that's why he charged him with the manslaughter as a lesser included offense, basically saying, hey, you created a high risk of death or great bodily harm, and that therefore that killing was not justified.
Of course, and Prosecutor Becker even mentioning by name that heat of passion that you talked about there. So very good chance we'll see that self-defense argument come back into play. This is going to take place in Kent County. It is going to be prosecuted by Chris Becker, who levied those charges today. Several reporters asked questions about potentially moving the case somewhere else where it could be tried on more neutral ground, perhaps. Do you foresee any issues as far as jury selection or as far as how this case plays out here in Kent County, with being in the actual county where this incident happened?
No, I don't see that happening in Kent County. I think the jury is actually going to be seated in Kent County, and the trial will actually take place in Kent County. I'm sure Officer Christopher Scher has been arraigned. He's going to have a probable cause conference within 14 days. And his preliminary examination by right has to be within 21 days of that arraignment, unless it's waived by him.
Yeah. All right. Well, Louis Langham from WMU's Cooley Law School, we appreciate you being here. This won't be the last time we hear from you. We've got you all afternoon, so thank you, and we will see you again in just a minute.